Good morning and welcome to this session covering subsidy control in the UK. I'm Sam Baton. I'm a partner in the EU Trade and Competition team here at Gowling WLG. And what I will be covering today is an overview of the subsidy control regime, thinking about firstly post-Brexit, where are we now? How do things stand in terms of the legal landscape? And then really spending some time on the new Act, the Subsidy Control Act 2022, thinking about some of the overarching themes that emerge from that Act and the accompanying regulations and guidance, focusing upon what is a subsidy, thinking about when a subsidy can actually be awarded, touching upon the transparency obligations that arise under the Act, and then thinking about how can a decision be challenged in the context of the Act. And I wanted to then just wrap up with some key takeaways. In terms of timing, one thing that I found in terms of putting this together is there's actually a lot of content, and I will cover this in more detail, but a lot of content. I have got an hour for this session. I'm aiming to leave some time at the end for some questions if there are any. I think my challenge is going to be covering content and making sure I'm giving you a broad overview within the time available. So without further ado, as I touched upon, this session is intended to provide an overview. This is an expansive area. There are lots of issues, lots of moving parts to all of this. Please do raise questions in the Q&A as we're going through the session. If I don't answer them, I don't have time to answer them now in the session, I will pick up by email in response. So please do leave contact details, or feel free to get in touch after the session. If you've got any burning questions, burning issues, this prompts any thoughts, we'd love to hear from you on that front. Another note of caution in terms of housekeeping. Legal concepts will be addressed during this session. So if that's a cause for concern or an issue, please do switch off. We've tried to make this as sort of practical as possible, but I'm afraid with the new regime, inevitably there does come a degree of focus upon concepts and technicality. So post-Brexit, where are we as we stand here today? Pre-Brexit, very, very clear focus upon the EU state aid regime. And under that regime, as I think we'll be aware, subject to exemptions, a member state could not grant state aid without notifying the Commission and obtaining approval in advance. However, there were lots and lots of exemptions. So by July 2021, more than 96% of new state aid measures were being exempted. They weren't requiring this notification process. When we had the end of the Brexit transition period on the 31st of December 2020, we had a situation whereby EU state aid as a regime ceased to apply across the UK. However, this was subject to significant exceptions, which are still being worked through today in the context of, for example, the Northern Ireland Protocol. So when we had the end of the Brexit transition period, what we had was a situation where international obligations applied. So the subsidy control provisions within, for example, the TCA, the EU-UK Trade and Cooperation Agreement, and other free trade agreements applied, as did our obligations as a UK country under the WTO Agreement on Subsidies and Countervailing Measures. The international obligations applied, but there was no UK-specific regime that exists at the end of the Brexit transition period, so end of 31st December 2020. There's nothing focused upon domestic subsidy control. And that essentially is the gap that the Act seeks to fill. So the Subsidy Control Act received royal assent on the 28th of April 2022. We've then had a short time period before it's implemented in full. It's now in full force, entered into full force at the start of this year. And the whole purpose of this is to give UK authorities, designed specifically for UK authorities, to give them a freedom to deliver funding to businesses in what's been described as a quicker, fairer and simpler way without being bogged down in long-winded and unnecessary approval processes. So this is meant to mark a very clear sea change from the old EU state aid regime to the new Subsidy Control Act. So we only have to worry about the Act then, that's great, that's very easy. Well, that's not quite the full picture. So the Act does not apply to subsidies that are in the scope of the Northern Ireland Protocol and the withdrawal agreement. So for those specific subsidies, then the EU state aid regime is going to still apply to those. And the Act was developed to support compliance with international obligations. So for example, the TCA, the World Trade Organization rules, but those international obligations, they still remain in addition to the Act. So the Act is an additional piece of legislation. It sits there for most subsidies that are granted in the UK. I anticipate the Act will be what we are focusing upon. However, we mustn't forget that these other regimes can and do apply to EU state aid as well as international obligations, and they remain in force in addition to the Act. And necessarily, this is going to require case-by-case assessment. So against that backdrop, if we think now about the Act, and what I want to do here is take a bit of a whistle-stop tour. I'm not going to cover everything because there isn't the time, but just picking out some, I think, the key themes, some of the key issues to be alive to at the moment. So thinking about overarching themes, I think the first thing I would say, and it's something I've certainly had to grapple with, is this is a new regime under the Act. So we cannot simply rely upon our old EU state aid thinking. So if you've been in this area for quite some time, and maybe 5 or 6 years ago, a certain transaction was done in a certain way, don't rely upon that because it may well have changed under the new regime that we have in force. The Act is intended to provide greater flexibility regarding the award of subsidies. The emphasis is now shifted. So the shift is to the public authority, and it's the public authority that's going to need to self-assess the award of a subsidy. And in that context, I think public authorities will inevitably have to work closely with the beneficiary when they're assessing specific aspects of that subsidy. And we can again look at that in more detail in the session a bit later on. We have a new review function under the Act. And what this requires is that for certain subsidies, so subsidies or schemes of particular interest, they must be referred by public authorities to the Subsidy Advice Unit, which has been set up within the Competition and Markets Authority. For other types of subsidies, which are known as subsidies or schemes of interest, these may be referred voluntarily by public authorities to the SAU. And in terms of the SAU, its role is effectively to assess the public authority's self-assessment and then report back upon that. And those reports will be published. The reports are not binding, but as we will see, they may be expected to have consequences. And what we see underpinning this new regime is a requirement for transparency in relation to the award of subsidies. And that transparency obligation is there to enable interested parties to become aware of what has been awarded and then to potentially challenge those awards before the Competition Appeal Tribunal, or the CAT. And the CAT scrutiny of a public authority self-assessment is on a judicial review, so it's on a JR basis, and it's going to be the interest of both the public authority and the beneficiary to ensure that whatever self-assessment's been taken by the public authority, this has been done appropriately. And I think really critically, and we'll see this as a theme throughout this session, that whatever's been done can be evidenced. So it's no good that there has been some excellent thinking and analysis done, but there's no documentation. There needs to be this clear audit trail evidencing what has gone before in terms of that assessment process. I think another thing just to flag at this juncture as well is we obviously have a new regime. It's all tremendously exciting. There's lots and lots of guidance notes to read and secondary legislation to get your head around, but this is yet to be scrutinised in any courts. So we don't have that body of case law that we did have under the old EU state aid regime, which means that while we have some starting points, the application of this Act is likely to evolve, as with any. So this is a bit of a moving feast in terms of where we will end up along this journey in our brave new world. So to begin at the beginning, what is a subsidy? So under the Act, a subsidy means financial assistance which is given from public resources by a public authority. It confers an economic advantage on one or more enterprises, specific in that it benefits one or more enterprises over others, and has or is capable of having an effect on competition or investment within the UK, trade between the UK and a country or territory outside the UK, or investment between the UK and a country or territory outside of the UK. Now, I'm not going to go through all of those limbs, but it's important to flag that all 4 limbs of the definition need to be satisfied for there to be a subsidy. I will pick out a couple that I think are of interest though. So financial assistance, I think it's really, really important to flag this is a broad concept. It deliberately includes lots and lots of different things. It could be a grant, it could be a loan, it could be a guarantee, so a contingent transfer of funds, could be foregoing revenue otherwise due, providing goods or services, purchase of goods or services. Broad range of things covered within this concept of financial assistance. I think what's a really important aspect of the definition, though, is this idea of conferring economic advantage on one or more enterprises. And why that's important is because this aspect breaks down into two elements. So we have first this idea of an enterprise. Now, an enterprise, for the purpose of the Act, is a person or a group of persons under common control, so a corporate group, for example, that's engaged in economic activity. And that sits in with the EU approach to economic activity, that is the offering of goods and or services on a marketplace. So if there is no enterprise receiving an economic advantage, for example, if funding is being provided to an organization that is not active in offering goods or services on the market, it may be set up perhaps an NHS body which is just focused upon public service, wouldn't be an enterprise, therefore this limb not satisfied. So there has to be this transfer of an advantage on one or more enterprises. And then the idea of conferring an economic advantage, that exists if financial assistance is provided on terms that are more favourable than might be reasonably available on the marketplace. So it doesn't mean they have to be available on the marketplace, but might reasonably be available on the marketplace. And there will obviously be no economic advantage if the terms might reasonably be expected to be available on the market. And this is known as the commercial market operator principle, the CMO principle. This, in effect, is aligning with notions under EU state aid law, but has been redefined as CMO principle. So to see the CMO principle in operation, if we had a public authority that was purchasing services, it's undertaken a competitive procurement process, which has enabled there to be the equal and non-discriminated treatment of all bidders. It's been an open and transparent process, and it's been carried out in a proportionate manner. That is something which you would say, well, actually, there's a really, really clear-cut argument here to say that was done on a commercial basis. CMO principle applies. There is no conferring of economic advantage. You're paying a market price for those services. Similarly, if a public authority is providing a loan on terms that could reasonably have been provided by a private investor. So if there's perhaps a benchmarking exercise, and you can point to the fact that in the open market, private investors with similar appetite for risk, looking at the loan that's being made, again, thinking about the risk of that loan, they will be making it on comparable terms. And here's a benchmark analysis, and this loan sits within that range of what's reasonably available in the marketplace. Now, as I mentioned previously, the evidential burden is going to be upon the authority. So if they're looking to rely upon the application of this principle to say, whatever we are awarding is not a subsidy because it falls in the CMO principle, that will be for the public authority to evidence the application of that principle. And another aspect, which I think is again just worth bringing to mind, is this notion that a subsidy needs to have an effect on competition or investment within the UK. And when we're thinking here about this effect, what we have from the guidance is that the financial assistance must be capable of having a genuine adverse effect that's more than incidental. So it must be foreseeable that the financial assistance will or is capable of producing that relevant effect. And this will require an assessment of the market or markets in which the beneficiary is active and the nature of competition and investment flows. And I think what we've learned from the guidance, and I think this is really quite key for us all to start thinking about, is that this means a measure could have a relevant effect even if the market covers a very small geographic area or the amount of financial assistance is actually comparatively quite low. And there's an example in the guidance where a local council is giving a grant to a newsagent, which competes with another newsagent, and they're both in the same remote village. And that is flagged as something that could have a relevant effect upon competition investment within the UK in the context of that grant being a subsidy. And I think from my position, from my perspective as an advisor on state aid for a number of years, I am well used to the state aid regime focusing upon cross-border effect upon trade, and where you can perhaps get comfortable where money is being given, it's for perhaps a swimming pool or a leisure facility, which has commercial operation, but actually the only people who would ever use the facility are within a very, very small locality. They're all within one country. you can rule out cross-border effect on trade and get comfortable with the provision of that funding. The specific focus of the Act upon effective competition or investment in the UK allows for a much broader application of the Act. We're not thinking about cross-border effect. We're thinking about this could actually be a very small geographic area, and that is something which enables this Act to apply in a way that is broader when we think about the EU state aid regimes. I think that's just an instance there where under EU state aid thinking, we could perhaps all get comfortable that certain local issues wouldn't be problematic, but we don't have that concept under the Act anymore. We need to start thinking more about it could be in the same vicinity, it could be affecting a small local area. You know, these are things that could fall within the definition of a subsidy. Another thing to flag is that the Act also enables the creation of subsidy schemes, and a subsidy scheme effectively sets out rules of eligibility, terms and conditions under which possible subsidies can be awarded in the context of that scheme. It's generally not a binding commitment, unlike the award of a subsidy, and public authorities, I suspect, are going to want to retain discretion to determine which subsidies are in fact be awarded under the scheme. So let's assume we have intended financial assistance and this satisfies the definition of a subsidy. And the first question to ask is that subsidy generally prohibited by the Act? Because if a prohibited subsidy is identified, then it goes without saying that is going to need to be redesigned and rethought. So examples of generally prohibited subsidies include unlimited guarantees, where the subsidy is contingent upon export performance. So this is tied to actual or anticipated exportation or export earnings. It's contingent upon the use of domestic goods or services over imports. There's an express exclusion there for the audio-visual sector, but otherwise, you know, this applies where the requirement is for domestic goods or services to be used rather than imports. Other examples include where the subsidy is contingent upon relocation. So the enterprise is required to relocate all or part of its economic activity from one area of the UK to another. There is a carve out there where this is for the purposes of addressing social or economic disadvantage, but that requires further assessment in the context of that carve out. Another example of prohibited subsidy would be where the subsidy is to rescue or restructure an ailing or insolvent enterprise. And again, unless there are specific requirements that are satisfied in connection with that subsidy, but there's a general prohibition upon those rescue or restructuring subsidies. And in addition, and we will touch upon this, a public authority cannot award a subsidy of particular interest without having first referred that to the SAU and the cooling off period following the SAU's report having expired. But let's say we're not prohibited. So we've still got a subsidy. Could this perhaps be awarded as minimum financial assistance or as a service of public economic interest assistance? So thinking about minimum financial assistance, I think, again, if we're thinking to try and align this with the old EU regime, we'd be thinking this is, you know, a kind of de minimis type exception here. So if we're thinking about minimum financial assistance, MFA, the threshold is value of up to 315,000 received over the applicable period. And the applicable period is the elapsed part of the current financial year, so that's from 1st of April onwards, and the 2 financial years immediately preceding, so 1st of April, 31st of March for the previous 2 financial years. Now, there are accumulation rules that apply in the context of MFA, and that means authorities will need to factor in any other low value support that's been received by the beneficiary, either prior to the Act entering into force or any other MFA awards that have been made under the Act. And MFA awards, where these are over 100,000 by reference to each award, those are subject to transparency obligations, which we'll touch upon later in the session. Now, in the context of making a subsidy award as an MFA, there are a number of procedural requirements that need to be satisfied. Those include there's a requirement for the public authority to obtain written confirmation from the enterprise that the MFA threshold will not be exceeded on the award of the subsidy. And in this context, as with all of the Act, when we're thinking about enterprise, we are thinking about both persons, but also a group of persons under common control. And that you can see how that could present perhaps some questions about, if you've got a big corporate group, Same activities being carried out by different enterprises, different companies within that group forming the same enterprise. How do you get that confirmation? How do you understand what's happened in that group? That's going to rely upon the beneficiaries' internal processes in terms of how they're accounting for their assessment of MFA awards. The MFA award can only be made once confirmation has been received from the enterprise that the threshold will not be exceeded. And when awarding an MFA subsidy, the public authority must provide the enterprise with written confirmation that this is being given as MFA and state the date on which the subsidy is given and the gross value amount of that subsidy. And then the enterprise needs to keep a record of that for 3 years. They need to be recording the amount of the MFA subsidy and the dates on which it was received. And this again goes to that whole point around accumulation. So if it is the case, you've got MFA subsidies being awarded, those need to be logged, documented. The public authority want to be doing that, the beneficiary want to be doing that, just so there again, it's that clear paper trail and everyone knows where they stand when it comes to totting up these values and working out what headroom there may be for future awards of subsidies if you're looking to do that under an MFA. So touching upon SPEIA, services of public economic interest. These are services that are provided to benefit the public. These are services which would not be provided or not be provided on the terms required under normal market conditions by an enterprise. Now, there are specific requirements under the Act which need to be met to provide a subsidy for services of public economic interest. I'm afraid that we do not have time in this session to cover those. What I wanted to touch upon was this threshold for services of public economic interest assistance, which is up to 725,000 being received over the applicable period. It's the same concept of applicable period in terms of elapsed part of the current financial year and the 2 financial years immediately preceding. The same rules and procedures apply to this assistance as to MFA, including those accumulation rules that apply. But that's another means by which an authority could, if it meets the relevant criteria, make an award using that threshold. But let's say we're not prohibited, but unfortunately, MFA and SPEIA, they don't really help us either. The next question is, should this subsidy perhaps fall within an available exemption? Now, there are a number of exemptions under the Act. I've just picked out a few here, but these would include things like compensation for damage caused by natural disaster or other exceptional circumstances, so perhaps a major pandemic. But the exemption only applies if it's been declared to apply by the Secretary of State publishing a notice, and the transparency obligations will still be applicable. It will also apply to subsidies that are awarded to safeguard national security. But if we're thinking about those, we also need to bear in mind that the UK's international commitments will still apply to the award of those subsidies. Another exemption would be for subsidies awarded by or on behalf of Bank of England in pursuit of monetary policy activities. So there are exemptions under the Act. However, they are quite closely and tightly defined, as you would expect. So for the vast majority of cases, I don't think the exemptions will provide much assistance when we're thinking about awarding subsidies. However, what may be more useful is streamlined routes. Now, streamlined routes have been created by the UK government to provide greater certainty for public authorities making awards. Within each streamlined route, it sets out effectively the terms and conditions of use. So it sets out the rules of use for the route in question. And where an individual subsidy is awarded under a streamlined route in accordance with those terms and conditions, it cannot be challenged on subsidy control grounds. There's a slight caveat to that. It can still be challenged on general public law grounds, for example, before the High Court. But what this does do is it does give that certainty that if you can get yourself within the parameters of a streamlined route, then you do have that additional comfort. This is something that cannot be challenged from a subsidy control perspective. There are 3 streamlined routes currently available. They were published, I think, in the first week of January, shortly after the Act came to full force, and they're respectively focused upon promoting local growth within the UK, increasing investment in research, development and innovation, and supporting the transition to net zero carbon emissions. And each of these represents a streamlined route with different approaches, for example, to things like aid intensity that apply under the route in question. But again, setting out those parameters whereby if you can satisfy the conditions or the terms, then this is something which falls within what appears to be, a proposed safe harbour. Any awards that are over £100,000 in value will be subject again to the transparency obligations. Streamlined routes are being kept under review, and the government's been really clear about this. They're being kept under review, and it may be the case in the future that the government decides to create additional routes, to create additional spaces within which public authorities have that greater certainty when it comes to making awards in the context of certain focused areas of the UK economy. Okay, but let's just say that the streamlined routes, although they look great, we've done some thinking around them, and actually they don't help us either. So we've got a subsidy, it's not prohibited, it's not MFA, it's not within an exemption, and it's not within a streamlined route. Okay, so where do we go now? Well, the subsidy then needs to be assessed by the authority against the applicable subsidy control principles, and it cannot be awarded by the authority unless the authority is of the view that the subsidy is consistent with those principles. Now, the assessment to be undertaken by the authority should be proportionate to the size and potential impact of the subsidy. If it's a low value, limited impact subsidy, perhaps you've got a really clear track record of this type of subsidy, not really giving rise to concerns around competition, investment, etc., then I think you can get comfortable to say that a less detailed assessment may be the way forward on this one. If the subsidy is novel or potentially contentious, then you lean to a more detailed assessment being appropriate. If the subsidy is of interest or of particular interest, then more extensive assessment should be undertaken in accordance with the statutory guidance. Now, this idea of proportionality sounds very reasonable and very sensible. I think having looked at this and having thought about these thresholds, I think from my perspective, the relatively low thresholds for subsidies of interest and subsidies of particular interest, I suspect a significant number of subsidies are likely to require this more extensive assessment. So I think we need to give some thought to that, and I'll touch briefly upon that in this session. But by way of an overview, the 7 general subsidy control principles. Principle A, the subsidy needs to pursue a specific policy objective, and that's to remedy an identified market failure or address an equity rationale. So there needs to be that specific policy objective. The subsidy should be proportionate to that policy objective and be limited to what's necessary to achieve it. Subsidies should be designed to bring about a change of economic behaviour of the beneficiary. So if the beneficiary was going to do whatever it was going to do anyway without the subsidy, that subsidy is not going to be an effective subsidy. The whole point of the subsidy is to bring about this change in economic behaviour of the beneficiary. And subsidies should not normally compensate for the costs that the beneficiary would have funded in any event. Principle E, subsidies should be an appropriate policy instrument for achieving the policy objective. And it shouldn't be the case that that objective that's been defined could be achieved through less distortive means. Principle F, subsidies should be designed to achieve the policy objective while minimising any negative effects on competition and investment in the UK. And principle G, which is a kind of balancing approach whereby the beneficial effects of the subsidy should outweigh any negative effects. And that includes in particular, and again, I've underlined this, negative effects on competition and investment within the UK, as well as international trade and investment. In addition, there are specific energy and environment principles that need to be considered where subsidies and schemes relate to energy and the environment. Just picking up on a couple of those points though, the statutory guidance provides a general framework for assessment. And in that general framework, it takes those 7 principles and it kind of groups them together into 4 different steps, grouping them together. I think there's a risk there that if you take a grouped approach, you perhaps risk not addressing each of those particular principles. I think when you're bearing in mind the possibility of a future challenge, I think it's really sensible for public authority to ensure that it documents the evidence analysis and conclusion it reaches in relation to each principle, so that if push came to shove, you could demonstrate as a public authority how you satisfied yourself with regard to principle C, principle D, principle E, rather than there being sort of a stepped approach, which perhaps risks inadvertently missing out or making an assumption around a particular principle without actually addressing it. I think also there's a really clear role here in my mind for the beneficiary to seek to assist. And when we think about the evidence that the authority is going to have to consider, some of this will not be within the authority's gift. There will be things the beneficiary, acting in certain markets, they will have a much clearer handle on than the authority. And I think there is a role there for the beneficiary to assist, whether that's providing third-party reporting, third-party data, market surveys that are undertaken. That is all good, helpful stuff, I think, in the context of some of the analysis that's required. And I think, as I mentioned before, when we're thinking about subsidies of interest and subsidies of particular interest, they are subject to more extensive assessment. And I think just touching upon the guidance there, I picked out principles F and G with this focus upon negative effects on competition. The guidance provides, when we're thinking about competition, the public authority should identify key markets that a subsidy may affect, and that in doing so, they may have regard to things such as markets addressed in merger and competition law cases. I've just quoted here from the guidance that a carefully delineated market should comprise the most important competitive alternatives to each of the recipient's products and services that are affected by the subsidy. Now, this all sounds really simple written down. When you start to think about how that analysis works, so you're required for these particular principles in the context of subsidies of interest and particular interest to engage in more extensive assessment, and that includes thinking about market definition to work out what that market looks like, what the parameters of competition on that market are, and how the subsidy may affect that competition in that marketplace. That can become quite difficult, and there isn't, unfortunately, a one-size-fits-all approach to market definition, because there are different products and services that may have perhaps a regional reach, could have a local reach, could have a national reach. There are lots of questions that arise in that context. So I think it may well be the case authorities find themselves needing that additional input, whether that's from third parties, from economists, from lawyers, from beneficiaries, just to assist them in identifying, what do these markets look like and what are the negative effects likely to be in relation to competition. So I've referred on a number of occasions to subsidies of interest and of particular interest. I want just to drill down a little bit more into what those are and how they work. So subsidies of interest are considered to have potential risk of negative effects on competition or investment in the UK, or trade or investment between the UK and a territory outside the UK. A public authority intends to grant a subsidy of interest can voluntarily refer this to the SAU for review, and the SAU has a discretion to accept a voluntary reference. A subsidy of particular interest is considered to have a higher potential risk of negative effects, and the public authority is under an obligation to refer that to the SAU for a review. And in that context, the SAU must review any and all subsidies of interest, subsidies of particular interest that are referred. So thinking about subsidies of particular interest and the thresholds applicable to those, where a subsidy affects what's known as a sensitive sector under the Act, it will be a subsidy of particular interest if it's over £5 million in value, or it's over £1 million and cumulates to over 5 million when other related subsidies are taken into account over the applicable period. And it's the same applicable period, so it elapsed past the current financial year and the 2 financial years immediately preceding. So we think about those numbers, quite low numbers there. Sensitive sectors in the context of subsidies of particular interest, they would be subsidies where the activities falling under the following codes would be impacted. And I think here, if we think about, for example, up and down, manufacture of motor vehicles, you're thinking how important to the UK economy the automotive sector is, you can see how subsidies in the context of the automotive sector, going to automotive manufacturers in the UK, this can quickly become something that would be a subsidy of particular interest, requiring that more detailed assessment and notification to the SAU. Outside of sensitive sectors, the subsidy will be of particular interest if it is over £10 million in value or over £1 million in value, but again, it accumulates to over 10 million when taken into account with other related subsidies over the same applicable period we've touched on before. In addition to these general thresholds, a subsidy will also be of particular interest if it's granted for restructuring ailing or insolvent enterprises, or going back to thinking about relocation subsidies, it's a relocation subsidy valued at over £1 million. So thinking about subsidies of interest, so a subsidy will be a subsidy of interest if it is over £5 million up to £10 million. Again, that's individually or cumulatively over the applicable period, and it does not satisfy any of the thresholds that apply to a subsidy of particular interest. So a bit of a catch-all there in terms of subsidies of interest. And thinking about accumulation, so a subsidy needs to be accumulated in the context of particular interest and interest subsidies if it's awarded to the same enterprise. And again, we're thinking about the corporate group potentially rather than to an individual company. And the award is for the same or substantially the same project costs or activities. It's for the same policy objective or substantially the same policy objective on the principle A, and it falls within our applicable period we're thinking about. So confirming the position in relation to accumulation, I think is really relevant to assessing whether this is going to be a particular interest or of interest. Because when we think about those value thresholds outside of sensitive sectors, these accumulation rules, if we can actually say, well, that subsidy was given to the enterprise, but it was actually for a different policy objective, and therefore it falls outside of the accumulation rules, that may mean we get to a position where we're not needing to make a mandatory referral to the SAU. We may wish to make a voluntary referral, but we won't potentially have to make a mandatory referral. So then getting to the bottom of accumulation early, I think, is important in that context. So I've touched quite a bit on referring things to the SAU. I think just to outline a little bit of process in relation to that. So where the SAU receives and accepts a referral, it will then publish a report which evaluates the authority's assessment of the relevant principles, and that will include addressing any effects upon competition or investment in the UK. And the report the SAU publishes may also include non-binding advice upon how the assessment might be improved or the subsidy modified to ensure compliance with the law. Now, this is non-binding. The authority remains ultimately responsible for deciding whether or not to grant the subsidy or to proceed with the scheme. But I think it's important to flag that the report may well be expected to impact upon an authority's decision-making, particularly if there's a heightened risk of challenge. If the report identifies various concerns about the assessment undertaken, indicates that the subsidy is unlikely to be compliant, then I think it's going to be very unlikely an authority would ignore that report, say it's non-binding, and proceed to grant the award of the subsidy. So it's non-binding, but I think that wording perhaps downplays the role these reports may well have in the future of the act that's applied in the UK. And then thinking through some of the practical aspects of the SAU. So we've got guidance from the SAU. I think we've had one case referred to so far. In terms of actual application of processes, what we're seeing is the SAU is very much encouraging authorities to engage in pre-referral discussions. And in part, that's to consider the information that the SAU is going to need to receive in the context of a referral. So the requirements of a referral and the information provided are set out, they are stated. There's a lot of content in there. And I think it's really important to ensure that these discussions do take place, particularly this early stage of a regime where everyone's kind of feeling their way a little bit about how this operates on the ground. Where the conversations have taken place, where the discussions have been undertaken, the whole point is to make sure that the referral, when it's made, can be accepted as complete. So you're not losing time with the authority, having had something in which raises perhaps more questions than it answers. The authority and the SAU are then engaged in backwards and forwards with information being requested and provided. That potentially could be wrapped up to a greater or lesser degree by engaging in these pre-referral discussions. The preparation of a referral is likely to be, and this is quoted from the guidance, a significant task. So I think everyone's acknowledging this is not necessarily a walk in the park. There is a lot of work to be done in preparing a referral. And in that context, I think it's important for authorities to ensure that sufficient time is allowed for meaningful pre-referral discussions to take place. So in the context of UK merger control, it's not uncommon for there to be discussions, pre-notification with the CMA that last for 6 to 8 weeks. So I think when we're thinking about time for pre-referral discussions to take place, we're again thinking about weeks rather than days. And the fact that pre-referral discussions are taking place will generally not be publicised by the SAU. And then once a public authority submits a referral, the SAU has 5 working days to confirm whether this is accepted or not. So it may not be accepted if it's incomplete. Again, if a party has not availed itself of discussions in advance, has submitted what it thinks it needs to be submitted, it may well find that comes back quite quickly saying it's incomplete and this is the additional information we require for this to be reviewed again. However, if it is accepted as complete, then the SAU has an additional 30 working days to evaluate the public authority's assessment by reference to the principles and publish its report. That time period is not set in stone, so it is capable of extension. So the authority and the SAU could agree, for example, to extend that time period. If the subsidy in question is of particular interest, then it may not be granted until the expiry of a 5 working day cooling off period from the publication of the SAU's report. Again, that is capable of extension in certain limited circumstances. However, if it's only a subsidy of interest that's been referred, then it's possible for the authority to grant that during the process of the referral. If it is granted while the SAU is still looking at this, then the SAU has the discretion to decide not to proceed to publish a report, to conserve its resources, to show up a report, and to not carry on down that route. I mentioned previously that the transparency obligations, I think, really underpin the scrutiny of awards in the context of the Act. And just to touch then upon those in the time available. So BEIS maintains a database that public authorities must use to satisfy their transparency obligations under the Act. And ultimately, public authorities, while BEIS maintains the database, they are responsible for the accuracy of the information that they upload on this. All standalone subsidies need to be uploaded subject to certain exceptions. So if we have SPEI subsidies, MFA, SPEIA subsidies, awards under the streamlined routes, they do not have to be uploaded if they do not exceed £100,000 in value. And subsidies under a scheme do not have to be uploaded, again, if they do not exceed £100,000 in value. All subsidy awards that are to be uploaded must be uploaded within 3 months of the decision to award the subsidy. So that's not the award of the subsidy, that's the decision to award the subsidy. So it may be the authority has decided to award that, they've informed the beneficiary, they've made that decision, they can then put that onto the database before they've even awarded the subsidy in certain circumstances. So it's not the date of the actual award of the subsidy, it's the decision to award, which gives authorities a bit more flexibility in terms of when they decide to make that decision and then get things onto that database. And there's a reason why they may want to do that, which we'll touch upon. The only exception to that is awards in the form of tax measures. They need to be uploaded within 1 year of the date of the relevant tax declaration. Now, I said transparency underpins this possibility of scrutiny as a challenge. Worth, I think, us just touching upon that. How do you challenge the award of subsidy? So interested parties, and I think we will be thinking primarily here, I suspect that could be most likely competitors, may apply to the competition criteria of CAT to review decisions. Now, certain types of decisions can be reviewed by the CAT. That is decision to award a subsidy. So a subsidy not awarded under a subsidy scheme or streamlined route, so a standalone subsidy, or a decision to make a subsidy scheme including a streamlined route. So CAT can review those types of decisions. CAT can determine whether a public authority has complied with its duties under the Act, and it will be reviewing decisions on general public law grounds. The CAT is also able to determine whether a measure was in fact subject to EU state aid rules, for example, by virtue of the Northern Ireland Protocol, and whether it is in breach of those very same rules. When reviewing subsidy decisions, the CAT is going to be applying judicial review principles. The CAT finds the decision has not been made lawfully in compliance with the Act. It has a range of remedies it can order. Those include, for example, prohibition order, a quashing order, where the authority has to set aside the decision and is required to reconsider and remake the decision. And in the context of these specific subsidy control decisions, the CAT has the power to order recovery. So the authority can be directed to recover the subsidy from the beneficiary. I touched before on getting things onto the database sooner rather than later may be in authorities' interest. The reason for that is because this challenge window in part runs based upon uploads to the database. So once a relevant subsidy decision is uploaded to the BOSE database, an interested party generally has 1 calendar month to apply to the CAT for a review of that decision. However, and there is a specific process to be followed in this context, if an interested party makes a pre-action information request to public authority within 1 month of the decision being uploaded, then the authority is required to respond to that request within 28 days and confirm to the party it has done so by giving notice to the party. And the party then has a further calendar month from receiving notice from the public authority to apply to the CAT for review. So this process around the pre-action information request effectively enables an interested party to elongate that challenge window. So they can approach the authority as long as they tick the boxes, as long as they are hitting those requirements, then they can effectively extend by 1 calendar month plus the time they have available to apply to the CAT for review. So I suspect, given that this is not something that's particularly difficult or costly to do, we will see lots of interested parties, if they are looking to make challenges, making the pre-action information request, so they then have the benefit of additional time in the context of preparing and putting together their challenge before the CAT. So touching then upon some of, I think, the key takeaways, some of the key themes that we have seen going through the session. I think at the outset, what I would suggest is that careful consideration should always be given to whether a measure is in fact a subsidy. I think it can be really tempting sometimes inadvertently to go with a line of thought where there's almost an assumption that a measure has to be a subsidy. And then when that measure is perhaps looked at and perhaps unpicked, and you start to think about applying that definition and is it going to an enterprise? What activities are they engaged in? Is this actually being done in a way that actually falls in the CMO principle? You may well find that the measure that at first blush appeared to be a subsidy may well be the case. This isn't actually a subsidy at all. And therefore we haven't got to worry about things like subsidy control. That can just fall by the wayside. If it is the case that there is a subsidy, and again, this will be case by case, and I suspect that the majority of measures would fall within the Act, but I think we do have to have in mind at all times there is this possibility of other subsidy control regimes applying. So, for example, we've touched upon this a number of times, but under the Northern Ireland Protocol, for example, we have the application of the EU state aid rules. So depending upon what is being awarded and how, we could potentially have a situation whereby the Act applies, but in addition to the Act, we also have the application of the EU state aid rules, and that could give rise to a whole host of complexities and issues. If they are identified early on in the process, then they can be factored in, time can be dedicated, they can be managed, they can be smoothed, that can all still work. If they're discovered at the 11th hour that you have a dual application of the Act plus EU state aid, that could give rise to a whole host of issues, unwelcome distractions, particularly if things are moving quite quickly at that stage. It feels like a massive spanner in the works that could be avoided. Where the Act applies, and I will keep telling myself this as much as anyone else, don't rely upon old EU state aid thinking. I think that what we've seen so far from the guidance is, I think, quite clear attempts to break with some of the old EU state aid thinking, to reposition the subsidy control regime in the UK as the Act, this being a domestic UK-focused piece of legislation which should be applied on a standalone basis without reverting back to thinking about EU state aid principles. The devil is certainly in the details of the Act and the accompanying guidance. There is a lot of guidance, there is a lot of detail in the Act, there are various pieces of secondary legislation. They have been published at different times, they have different, in some respects, look, feel formats. You've got guidance being issued by the SAU in addition. There's a raft of detail out there. And I think it's really important when people are engaging with the Act, with the regime, given how new it all is, to really think about those details and to know that this is something that does need thought, it does need questions. It's not necessarily a quick fix, so dedicate time to this. And that, I think, means working methodically when you have got a subsidy in your hands, the various means by which that can be granted under the Act, and keeping that clear audit trail in relation to any decision making. And then when assessing a subsidy against the relevant principles, as I mentioned before, it may well be the case that additional input will be helpful, particularly when we're thinking about that more detailed assessment in the context of subsidies of particular interest and subsidies of interest. So if it is the case that we are thinking about negative effect on competition, that point about market definition, I think that over time, authorities are going to have to grapple with that at some point. It may well be, if people are lucky, there is a recent CMA merger case, for example, that touches upon the same goods or services, which sets out quite clearly what their competitive alternatives are, the geographical area in which they compete with those alternatives. And that could be, a very nice thing to have fall into your lap. It may be the case there's very little thinking around the services in question, or the products in question, or the geographic area in question. And that means that will need to be built up by the authority, working with the beneficiary, potentially economists, potentially lawyers, just to work out, what would be something that would be a defendable position to take here in terms of our market definition. What evidence can we show that we have actually thought this through? How have we engaged with this? How can we pull that together into a package whereby if we're sending this to the SAU, they're going to look at this and that's going to be credible, and that's going to result in a report which says, yeah, we have given this due consideration. As I mentioned before, I think it is really important, whatever we're thinking about here, when we've got the principles in play and that assessment of the principles is required, that each relevant principle is assessed by itself. So it's not lumped together with others. There is a clear line of sight whereby the authority can point to the assessment undertaken for each relevant principle. That's clearly documented. That includes the evidence that's been considered, the analysis undertaken, and the conclusion reached by reference to that principle. And there's a real piece here about being proactive in engaging with the SAU. And I think it's not possible to underestimate the time that will be required to engage in meaningful discussions. So I think people need to be, if they are on their radar that, okay, we perhaps need to think about SAU because we might have a subsidy of particular interest on our hands here. Whatever you're looking to do in terms of key milestones, you are building in plenty of time along that journey of the award to allow for there to be appropriate engagement with the SAU in good time. I think for a lot of authorities, if they are awarding a subsidy, then their preference would be to open that challenge window as early as possible so that this expires sooner rather than later. I think once that has expired, there is a degree of certainty you then have that, okay, this can't then be challenged under those subsidy control arguments. I think another facet within this new landscape is the SAU and the reports that it publishes. I think it's worth public authorities, as well as interested third parties, potential beneficiaries, I think keeping a watching brief on these reports. I think in this context, there is a role for the SAU to play in ensuring that their reports actually give some guidance. So by providing guidance that may assist future assessments, this should build up a body of decisional practice, reporting, whereby you have decisions to SAU to say, we assessed this, we were comfortable with this assessment on this basis, the authority did this well, this was best practice. or we have clear concerns because this is where they fell short of this particular requirement. I think having that guidance from the reporting will be invaluable to all interested parties when they're thinking about future assessments of subsidies. I think the last point I'd say is that, as I flagged at the beginning, this is all new. This is all new. The Act is yet to receive judicial scrutiny, and that means, although we do have these tram lines, we know where this is, we know it's heading, but the application of this, I think, is likely to evolve. So the more we have things going before the courts, the more we have judgments ruling upon the application of the Act, the more we will have that firm ground of application in terms of where the pitfalls are, where the safe harbours are. That it's already been laid out, but we will have, I think, greater certainty going forward about how this all applies, which will just take time to build up that body of case law. So I'm conscious I've covered quite a lot of ground in quite a short period of time. So thank you for bearing with me as I've run through that. I think we have got perhaps a few minutes for questions. If you do have any questions which you haven't yet sent in the Q&A, please do feel free to send those. I'm just going to pick out a couple now in the time that we have. Okay, so question here. Okay, so question about SAU. So SAU, if the SAU is asked to publish a report and they don't do that within the time period, what happens? Okay, so if you have SAU, they haven't published a report, it's for a subsidy of particular interest, which before, assuming they were going to publish a report, you'd have to wait for the expiry of the calling off period before you could grant the financial assistance. If the report hasn't been published, then you can proceed. You can proceed on the basis there hasn't been a report published, there is no calling off period, the time period has elapsed for the report to be published, the report has not been published, therefore you may proceed to grant the award if you so choose. For a subsidy of interest, as touched upon in the session, you don't have that compulsion not to grant the award. You would still be able to award in any event. Okay. So streamline routes. Streamline routes sound very similar to block exemptions under the older EU regime. Where can we find these? Okay, so streamline routes. I agree. I think that for all intents and purposes, you could think of a streamline route as being, very, very similar to the old block exemptions that we had under the EU state aid regime. The guidance that accompanies the streamline routes is it pains to make clear that these are not the equivalent of block exemptions. This is something completely different. But I think in terms of practical application, you definitely see very, very strong echoes of that block exemption concept, whereby you are creating the safe harbour. If you can sort of pull yourself into that safe harbour and craft your grant in such a way that you are satisfying its conditions, then you do have that comfort of effectively safety from challenge on subsidy control grounds. In terms of where you can find them, I think what I will do, I can send links when sending the slides around. The website, from my personal experience, isn't the easiest to navigate, and there are some things tucked away in there which are very useful, things like streamline routes. And there is a whole page dedicated to them. There are 3 routes set out along the guidance notes. I'll put a link to that in the email which attaches the slides. And I think we've got time for one more question. Okay, so value and subsidies. So value in a subsidy, how do you value a subsidy if it's not a grant? That's a really good question. So obviously some subsidies would be things like foregoing a value that's due, maybe things that are guarantees. There is a regulation, and again, I can put a link to this in the email sending the slides, which sets out specific means by which those non-monetary values are to be calculated. in the context of subsidy control regime. So there is regulation, it does cover that, but it's a really good point, because that's again something people will need to be thinking about, is valuing things that perhaps aren't, for example, a grant or a loan. Now, I'm mindful of time. I will pick up questions that I haven't picked up during the course of the session. You can pick those up by email. In the meantime, thank you very much for joining today. I do hope that's been of interest and hopefully of use, and look forward to seeing you at a future Think House event. Thank you.